Hello, class. We decided to do the Wood versus Safeway case. I'm Austin. I will also be presenting with Natalie. These are also our fellow contributors to this whole project. Historical context, the overview, it was a Nevada Supreme Court case filed by Paul Wood and Jane Wood. These are the guardians of Jane Doe, the victim. It was filed against Safeway and Action Cleaning. Historical context of Jane Doe: she was a mentally handicapped female. She attended Carson High School and she was enrolled in the special hiring program. Which ended up working with the Safeway special hiring program, which landed her a part-time job at Safeway while in high school. Then, once she graduated high school, she worked full-time as a courtesy clerk in June 1998. Historical context of the assaulter: Emilio. He worked with Action Cleaning, which is a subcontractor of Building One Services Solutions, which meant they would go out and clean janitorial stuff at like Safeway locations, specifically where Jane Doe is. Events leading up to the dispute: Jane was now 18. The assaults happened on 3 different occasions during the 4 p.m. to midnight shift. The first assault was in the cleaning supply room. The second and third were behind the Safeway dumpsters while Jane was collecting carts. Emilio pleaded guilty to 1 count of attempted sexual assault, and the results of all these sexual assaults was Jane getting pregnant and having a child. Legal issues: Jane Doe's guardians now take care of the child with Jane Doe. Would the family and Jane Doe file a complaint against Safeway and Action Cleaning? They filed alleged causes. The 5 alleged causes of this were: 1, negligent failure to train employees and maintain a safe work environment; 2, negligent selection, appointment, training, supervision, and retention of Emilio; 3, sexual harassment; 4, negligent infliction of emotional distress; 5, due to the above negligent acts, Woods are now responsible for the care and maintenance of Jane Doe and her child, Baby Doe.
So the main thing we want to look at is actually the torts at hand due to the assault that Jane Doe faced at her workplace. So the question we're actually going to be asking is whether the tort arose out of or in accordance with the scope of their employment. So the way we can see if this holds is that we can actually see that the tortious action was not committed within the action of the work and the task given, but actually the individual, Emilio, was seeking out his own personal thought when he was going through with the actions. So because of this, these actions just not being assigned with their employment, the liability is actually on the employee rather than the employer. This is why a judge is most likely to side with Safeway and the cleaning company rather than with Jane Doe herself. So then as we move on, we can actually see how the dispute was resolved. In this case, Safeway and Action Cleaning, the judge Bill Maddox ruled that both Safeway and Action Cleaning were immune from the suit under the NIIA. This is because this was covered by workers' compensation. He found that the sexual assault arose out of and during the course of her employment, of course, and therefore her claims are barred by the NIIA when she did receive that workers' comp. He did rule in Action Cleaning because they can't be held liable for intentional crimes by their employees under the related job functioning. The High Court again agreed with the ruling that there was no way for Action Cleaning to anticipate that a 10-year employee with no prior complaints about his conduct would commit rape and therefore couldn't be held liable, which is why they were not charged with anything either. Jane Doe had her favor, it was not ruled in her favor. She did, however, receive workers' compensation from her injuries received at work itself. So then while we go on, I just wanted to point out some interesting observations we found while looking at this case. So one of the big things was that because of the case with Wood versus Safeway Inc., we can see that the Nevada Supreme Court took the opportunity to actually abrogate and the viability of the slightest doubt standard, which is what they used to rule this case. The court adopted the federal standard for the summary judgment, stating the quote, that summary judgment is appropriate under NRCP 56 when the pleadings, dispositions, answers to interrogatories, admissions, affidavits, and any, if any, that are properly before the court demonstrate that there is no genuine issue of material facts exists, and it will preclude summary judgment. Other factual disputes are irrelevant. A factual dispute is genuine when evidence is such a rational trier of facts fact could return a verdict for the non-moving party. The court went on to clarify, while the pleadings and other proofs must be constructed in a light most favorable to the non-moving party, to avoid summary judgment in favor of the moving party, the non-moving party bears the burden to do more than just show that there was some doubt in the facts. The non-moving party must set forth specific facts demonstrating the existence of all genuine issues for the trial. So then that was like one of the main changes that happened. But as we go on, we can actually see that other aspects of the cases are there to review. So we can see that there were some changes to employee liability, that the Nevada Supreme Court did reinforce its prior case law, affirming that incidental or increased risk tests must be done during these cases. However, because of Wood v. Safeway, it did not alter the Nevada law in areas pertaining to employer liability for intentional criminal actions of the employees in the scope of their tasks. Some other jurisdictions is that Doe originally asked the court to look at another case just to help with her own case. The court did not take this case into consideration, citing that it would be irrelevant whether the case was a casual link between the employment and the assault, because the sexual assault could have been arised from privately held motivations rather than being because of the employment. The court further held that sexual assault would not be within the NIA if the animosity of the dispute, which culminates the assault, imported into the place of employment from the injured employee, private or domestic life, at least where the animosity is not exacerbated by the employee. So overall, that just seems to be a thing where they are for sure set on this case. But then overall, this is just something we saw in the case altogether and something we wanted to bring to light for you guys. But then that is the end of our case. Thank you for listening to us, and we hope you have a great rest of your day.